The Madlanga Commission just took a dark turn. A witness's lawyer accused the state of having a kill rate. Justice Madlanga's response? Absolute fury. Gratuitous and sensationalist were his exact words. Why is Suleiman Karim so terrified to testify in public? And why did his lawyers have to apologize to the judge? We've got the exact timestamps and the drama right here on Mzansi Brief. Let's get into it.
Defeat the main hearing. What you will, and now I speak with some hesitation because I'm now traversing potentially some of the merits of the in-camera application, and we're not yet at that stage. We're determining rules of engagement, if I can put it that way. What you will know is one of the arguments that is made in the in-camera is that my client started receiving death threats, and that those death threats emanated even before he gave his actual evidence at the commission itself. And so my client's position is that he is being subjected to those death threats regardless of the actual evidence he is going to give. Now, the fact that we are having this debate about whether he should then still give that evidence in camera or not in camera now reveals to the public at large watching in that he's been the subject of those death threats and that he might be made to give evidence, but it just will happen on a day or in a time or in a format that the public at large might not know about. But the consequence of that doesn't detract from the fact that my client, based on what he says in the affidavits, is that he's being surveilled. And the fact now that this has already happened on live television, with all due respect, does not, or rather does, undermine the very purpose of the in-camera, which was to protect that disclosure when he comes back to the commission to give his evidence in chief, if I can call it that. And because of the particular situation that my client finds himself in, the fact that we're already publicizing the fact that he's making the in-camera application is the prejudice that we are talking about. So that's on the first point, if I may, Chair. On the second point, I obviously can't answer for what other applicants did in respect of their in-camera application or whatever the case might be. I'm not privy to that. But on the facts of this case, and because of that surveillance which I've just mentioned, that's why a particular prayer was included in the notice of motion, prayer 2, that the actual argument of the in-camera be held in camera itself. And again, I say this without trying to traverse the merits of the in-camera application, but I'm just registering the difficult position now that my client is in, because the surveillance which happened from the previous session is now going to continue, arguably, from this moment in time, because if my client doesn't appear to the public's knowledge on the 9th and 10th, the public will know that he's compelled to give evidence. It's arguable that the in-camera was granted and that he's still giving the evidence with the effect that the threats are going to materialize again, with all due respect, because it effectively now has given publication to the very concern that my client had, that he's under surveillance.
So, Mr. Karim wants the public to be under the impression that he will not be testifying, or what exactly is the point?
That's not the case.
What then is the point?
No,
because if the public or even those threatening him are aware that he will testify at some point, what difference does any of this make?
The difference is, Chairperson, in the two alternative factual scenarios is, let's assume when we came in here this morning, this session was being conducted in camera, in the way that I had understood it would be. What that would mean, with all due respect, is that there would be no insight given to the people outside of this room that the in-camera application was made, and if it was granted, then the public knows that Mr. Karim ought to have testified on the 9th and the 10th, that he might not have materialized on the...
Even those threatening him will be under that same
Agreed.
impression.
Agreed.
So what's the
Agreed.
difference?
I was getting to that, if I can finish.
Yes.
What I was saying is that in the scenario that I'm talking about, that if these proceedings were in camera, on the 9th and 10th, if the commission is with me and grants the in-camera in substance, then whoever is threatening Mr. Karim and the public at large would be left to speculate, why didn't he give the evidence? Is he still giving evidence? Or whatever the case might be, insofar as Mr. Karim's appearance at the commission is concerned. That would not release Mr. Karim from the obligation to still give evidence, which he would give, but it's the details around that evidence and the session itself that would be protected and offer him an interim modicum of protection where he says, I'm being surveilled and I'm being threatened even before I give the evidence.
I don't quite see the difference in substance to what I said earlier, which was that, so Mr. Karim doesn't want the public to know that he will testify at one stage or another. The various options or possibilities or permutations you referred to boil down to, or at least part of it boils down to what I said, which is that he does not want the public to know that he will testify.
Yes, but that's not because he has, the case he's pleaded in front of the commission is not because he doesn't want the public to know, it's because of the threats that he's received.
But part of what you said, says exactly what I say.
No,
of the various permutations you gave, part of it says exactly what I say.
I accept that, but we
Yes.
also have to accept that there will be parts of your report, for example, that might be subject to certain confidentiality regimes. There might be evidence that is in your final report that is subject to certain confidentiality regimes which the public at large would not know about. So it's not as though Mr. Karim, with all due respect, is asking for something unique or specific to him that the Commission's rules itself does not contemplate. It's the Commission is being asked to strike the appropriate balancing act between making the witness testify, which Mr. Karim accepts he has to testify, obviously, but at the same time protecting him or offering him a measure of protection that neutralizes or potentially neutralizes some of the threats that he is receiving. With all due respect, I haven't taken an instruction from my attorney at the moment, but just speaking frankly, if this live television camera is on at the moment and it's being broadcast to the public, then actually my application for an in-camera hearing is potentially rendered moot, because the same people who are threatening my client even before he comes and gives the substantive evidence now know what he's attempting to do. And so with all due respect, I don't even know if there's any point in proceeding with the in-camera application, although my attorney might kick me if I say I'm abandoning it, because of this exact prejudice which has now manifested. I've heard what you've said to me, Chair, but I must obviously put my client's position regarding what is happening at the moment and how that potentially prejudices him in light of the relief that he sought under 4.2 of the Commission's rules.
You earlier said you may already be touching on the merits. Perhaps what I'm going to raise also touches on the merits.
Is this a preliminary concern now, Chair?
No.
Are we still on the preliminary?
I'm still on your preliminary.
Okay.
Preliminary.
Got you,
Yes,
Chair. Got you,
yes,
Chair.
Yes. How exactly, everything being conducted in the manner in which Mr. Karim suggests, how will the evidence then be dealt with in practical terms afterwards? For example, you even referred to the final report treating the evidence in a particular manner and perhaps even the public not having access and so on. So I'm raising what I'm raising
Yes.
in the context of
Yes,
that
yes.
submission.
I accept that, yes.
How will the Commission handle the evidence, assuming that the application is granted?
Yes.
Yes. I'm thinking, maybe let me just add, I'm thinking, for example, the evidence may say something about people who may either themselves on their own want to respond, or in respect of whom the evidence leaders may want to lead evidence that counters whatever Mr. Karim may have said. So how does all of this get handled?
I accept.
Because those people will have to know.
No, of course. And
content
I'm
of
not
the
suggesting that a case be conducted against them in their absence or without their fair trial rights being protected. As you know, Chair, my client is particularly keen on his fair trial rights. It would be ironic if he's attempting to The Minister of Finance is trying to phone me. That must wait until later. I apologize. I'm sorry, Chair, go ahead.
Yeah, oh, sorry.
Sorry, Chair, what I was going to say to you is that we obviously have no difficulty with whatever accommodation has to be made to facilitate the fair trial rights of any other witness who may be impacted by my client. But what we know, and that's foreshadowed with all due respect in Rules 4.2 and 4.3 of the Commission's rules. But what we know in practice from cases like Bryden and Helen Suzman Foundation in particular, which in your previous capacity, Chair, you would be very well familiar with. There are particular circumstances where the disclosure of evidence in a particular context is subjected to a confidentiality regime that appropriately balances the interests in the evidence coming to the court, or in this case, the tribunal, the inquiry as the tribunal forum, so that it can apply its mind to all the evidence and do its job, but also that the court, and here I would say the Commission of Inquiry under those rules that I have quoted, has an equal power to impose a degree of, and I'm hesitant to use the word secrecy regime, I'd rather use confidentiality regime, that protects interests that are implicated if it was just conducted in the ordinary manner, which is the open justice default position. And with all due respect, Chair, in Helen Suzman Foundation, building off the commercial case of Bryden, you were at pains to explain that this is that the kind of regime that Mr. Karim is asking for, including the kind of regime that you would be entitled to impose in terms of the rules for what happens in future, is the appropriate balancing exercise where constitutional rights are implicated. And because my client has claimed that there's a threat to his life, there's a threat to his family, there's a threat to his businesses, there's a threat to his employees, this is the appropriate instance that the Commission, and through you, Chair, must consider its own rules which enable such a balancing exercise, and then your powers to give appropriate directives to achieve that balanced outcome. That's what we would say. Of course, my attorney tells me that there are other witnesses. Karim's obligation to come here and to tell the Commission what the Commission wants to know and be subjected to questioning by the evidence leaders and the commissioners. It's about the threat that has been identified and what the Commission does in recognition of that threat and to exercise its powers we would submit it should do to protect him in light of that threat. That's really where we are, Chair. Thank you. I apologize if that was a very long answer.
No, understood.
Thank you, Chair.
Can I? Thank you. Maybe on just that last point, to start there, that other witnesses, including Mr. X, have testified in camera and arrangements were made to protect their evidence. That's not applicable here because all the decisions about witnesses testifying in camera is based on the testimony that they are going to give. You bring a completely different application at this stage.
Yes.
You say the application itself to be heard in camera should be in camera. So yours is not, I mean, those other cases don't apply to you here, one. But you, in your engagement with the chair, you speak to, you want to be heard in camera. There's actually two legs to your application. You want this very application to be in camera because you don't want it to be known why the reasons that he's seeking to be heard in camera. Well, they are out there now.
It's too late now. Yes, absolutely.
And as an aside, I would have thought ordinarily a person would want it to be publicized, that the concerns that your client has, that there are people who are making threats against me, they would want it to, the light to be shown on those who are making the threats on them so that they know the world is watching. I would have thought that's what your client would want to happen. But more importantly for me, you have two parts to this. The second part is you want the papers, including this application, So we are not yet in the merits. This very application that you are before us about and that you are arguing about, you wanted the papers to be shared only amongst a defined number of people in the commission. You say the chairperson and commissioners, the evidence leader designated to lead, Mr. Karim, the commission's appointed legal team, the secretary, Mr. Karim's appointed legal team, and the commission's official transcriber. You haven't said why you want to restrict, you want the commission to restrict who has access to these papers. And I've tried to read your papers. I don't see a case made for it, including for this leg of the application. I mean, it seems like your client is wanting something that, certainly I've never encountered anything like this, and he doesn't lay a basis why only these 7 or people in these 7 categories should have access even to this, even before you get to his statement on the merits or the application to be heard in camera, just even this preliminary issue. Can you just explain what's going on? I really don't understand this application. And on what legal basis does your client think he's entitled to have to prescribe, as he's doing, about who should have access to his papers? 1, 2, the legal basis for him to seek to be heard in camera, his application to be heard in camera. I've never, ever encountered that, and I don't see a legal basis for it set out in your submissions, but also the factual allegations, if there are any factual allegations here. I don't understand this application, Mr. Kermit.
May I respond? Thank you, Chair. Commissioner Baloy, thank you. May I start with the first question about the prescribing of the access? That is rooted in the understanding of the applicant of Rules 4.2 and 4.3, read with Rule 11, which on our reading, 4.2 says, in an appropriate case, the chairperson may make an order that a hearing be held in camera or via electronic means. In such a case, the chairperson shall specify in the order those persons who shall be permitted to attend the hearing in camera or by some other means. Then with 4.3, at the request of the witness whose evidence is to be heard in camera or meru motu, the chairperson must order that nobody may, directly or indirectly, disclose the identity of the witness who is to give the evidence in camera, and then read with Rule 11, which is the so-called catch-all rule, which gives the chairperson the procedural right to determine issues not otherwise prescribed in the rules.
Yes, what I'm trying to understand is this defined list. I understand the rule. I know what the rule says and the powers that it gives the chairperson. What I want to understand is, when your client says only the evidence leader dealing with the matter should have access to this application that we are concerned with right now, on what basis does he assert that kind of
Yes.
of request?
Yes.
We have a whole team of evidence leaders.
Yes.
We have investigators.
Yes.
Right? You know that.
Yes.
There is no explanation.
Yes.
Why those should not
Yes.
have access to this application.
Yes.
And I can put to you that, at least in my reading of your application, there's nothing confidential
Yes.
about it. He's not, your client is not disclosing any confidential matter. The best he does is to suggest that the threats are confidential. That's because that's the only basis on which he's seeking for this first leg to be heard in camera. And all he speaks to is the threats. So he's asking for the threats to be kept confidential. Why can that not be shared with the rest of the staff of the commission? Why shouldn't the staff be aware that there are these threats that he's relying upon?
Yes. let me immediately accept that on the strength of the affidavits as prepared and submitted in front of the Commission, there is no direct engagement with why the list curtailed in Schedule A is presented in the way it is presented. I accept that, and I'm not going to dispute that, because that would be a hopeless cause. But I hope that, Commissioner Baloy, you can see that there is a relationship in the exercise that is being done in Schedule A with what is set out in the rules that I've just read to you, in the sense that where in an appropriate case there is an in-camera consideration, the chairperson can make an appropriate directive to limit access as to who can or cannot have access to those proceedings and the papers. So
yes, I'm not having that debate with you.
No,
I know that's what the rules say,
exactly.
and we have used the rules.
Exactly.
What I'm struggling with, or what I don't see,
yes,
is how that gets to be applied, or how your client relies on that,
Yes.
given what he has
yes,
set out in the
and
papers.
that's why I started by clarifying by saying if you want that direct explanation in the affidavit, I have to accept it's not there. But why the Schedule A is attached to the notice of motion is because it's one of the prayers that are sought from the Commission applying the Commission and the chairperson applying his mind. If on the basis of no pleading, the Commission says, well, I can't grant you that relief because you haven't made out a case for that, then I have to accept that. But the reasonable explanation as to why there's an attempt not only to keep this application in camera, but limit who has access to the content of the application is threefold. Number one, Mr. Karim nor his legal team knows the internal processes of the Commission. And it might be the case that not everybody in the Commission needs to be involved in the Mr. Karim specific matters. And so the Commission might in and of itself have its own Chinese walls that it will sometimes enforce or not enforce in order to preserve the integrity of whatever's happening in front of the Commission, which I say applies here in an in-camera request. Number two is that never mind whatever the Commission's own internal processes are, practically speaking, in the light where the Commission, where the case made in front of the Commission is that I'm being surveilled, I am under threat, I don't know who's watching me or who's not watching me. At its most generous interpretation from Mr. Karim's side, obviously there's a less generous interpretation from the case against me, but the most generous interpretation that can be afforded to Mr. Karim is that that Schedule A, which was subject to the control of the chairperson of the Commission at all times, was an attempt to make sure that the net was not cast too widely so that all and sundry, and I'm using that phrase again, but I'm using it with respect, get access to the very papers that may or may not result in the breach or of Mr. Karim's rights in the way that he's saying in the papers. The third explanation, Commissioner Baloy...
The second explanation, put simply, is he doesn't trust the rest of the staff of the Commission that they may not distribute. Or in fact, he doesn't trust the Commission. He has to leave with a list in Schedule A, but he doesn't trust the beyond that.
I hope that the correspondence bundle has been placed in front of the Commission, because what you will see from the correspondence bundle is that my client has consistently complained about inconsistent treatment, about the Commission's inconsistent application of its own rules, and the prejudice that he has suffered as a result of the Commission's conduct towards him.
Is your answer to my question that, is it a yes? He doesn't trust that the Commission will not share his application outside of the Commission, that with the consequence that those who are threatening him would become aware of it. Is it a yes? That's my question.
It is a yes, but
Okay.
I hope you will understand, Commissioner Baloy, that it's not an out-and-out yes in the sense that, you know, my client is complaining about that this is just a farce exercise or that he won't get a fair trial. It's based on his experience at the hands of the Commission that that lack of trust arises. And I'm being very guarded in my language in making that point, because that implicates potentially not only my learned friend, the other evidence leaders and the staff of the Commission, of which there are many and they are unknown to me. And I don't want to trample upon the integrity of my colleagues, whom I have known and have no difficulties or issues with. It's just that obviously my client, given the treatment that he has been subjected to, has a legitimate concern which informs the application and the attempt to limit the access as explained in Schedule A.
Just to be clear, that treatment that he's complaining about and on which he suggests he relies for seeking to limit who has access to his papers, does it include a disclosure of whatever he submitted to the Commission to the public?
Does it involve breaches of confidentiality?
Well, it's difficult in the facts to answer that in circumstances where we only gave the statement yesterday. No, not yesterday, 2 days ago on the 4th at 9. The statement hasn't become public, which we're grateful for, but you'll remember that the only time we received the direction from the Commission that that statement was going to be kept confidential was when we received the directive, I think it's paragraph 6 or 7, that unequivocally states that whilst the in-camera is being fought over, the main statement will be subject to the in-camera treatment. So obviously, as a result of that directive, that remedies the concern of my client to some extent, as we sit here now, but it certainly animated my client's concerns prior to the handing down of that directive.
I guess what I want to do, Mr. Pramito, what I want to get out of you is it has to be clear that whatever your client's complaint is about the treatment he's received from the Commission, it does not include a complaint that the Commission has disclosed what he has to be confidential matter. It has been disclosed to the public. I think it is important for our processes.
Yes.
That is clarified.
That's
not what you're complaining about.
No, that's right. But if you have regard to the correspondence bundle, Commissioner Baloy, you will recall that that around the 28th of February, the Commission started making threats to my client that he was in breach of not filing the statement in terms of the 27th directive. But the Commission conveniently overlooked the fact that the disclosure or the submission of that statement was, in terms of the application that served in front of the Commission, to be pended until the in-camera was decided. And
but Mr. Karim can't make his own rules.
No.
There was, from where the Commission was sitting, there was no change to the directive that he should file his statement.
No, I accept that.
To characterize this as threats
I accept
is actually totally unacceptable, Mr. Premier.
With all due respect,
Mr. Karim cannot create his own rules. There was a directive that he should file his statement by a stated date. He could not, if there was no change to that direction, of his own motion, choose not to file. Just because he has said, by the way, I am not going to file because pending ABCD is not appropriate for me to file. He could not.
No, absolutely.
If, despite him having said so, the Commission did not change the deadline, it was not for him to choose by when he filed.
But with all due respect, Chair,
yes.
But with all due respect, Chair, on the 18th of February, which is the date that the application was launched, the following was said in that covering letter. And this is why we're having a debate which is slightly removed from the facts, with all due respect. The request was made.
I'm very sorry, I intervened.
Oh, sorry, I apologize. May I
intervened twice, my colleague was still asking you. Yes, please go on.
May I respond to you, and then Commissioner Baloy, subject to the Chair's authority, of course, if you can re-put your question to me, because I'm now dealing with what the Chair says. I apologize for that. But Chair, it's very important, because when the application was launched, what was explicitly raised with the Commission staff and the evidence leaders is a request that this entire application would be disposed of. This very in-camera application that we are asking for today would be disposed of by the 25th of February, which was before the statement was due, so that my client would know what his position was come the 27th regarding the filing of the statement and whether that was going to be in camera and then the hearing was going to be in camera or not in camera, because obviously the determination of the in camera might have also triggered my client's request to file a confidential affidavit with the commission. And so on the 18th of February, my client doesn't only say, please bring this to the extremely urgent attention of the chair so that a determination is made by the 25th before our statement is due. He says you can even dispose of this entire matter on the papers. We don't need an oral hearing because this is an extremely urgent matter. The issues are fairly narrow and we want an expeditious outcome so that we know what our client's position is. And with all due respect, what happens on the 18th of February from the commission, we get a one-line email saying, we confirm that same is in reference to the application, will be relayed to the secretary and the evidence leader shortly, and we will revert with formal instructions in due course. Nothing is heard from the commission from the 18th, 19th, 20th, 21st, 22nd, 5 days. And now you must remember, of course, that the statement deadline is coming nearer and nearer. And what we then do on the 23rd is we write to the commission on the 23rd to say, please can you advise us what the delay is, because our statement deadline is approaching. We might be wrong in the way that the chairperson puts it to me that it's not for Mr. Karim to determine, but we need some clarity from the commission, the chair in particular, as to what the next steps are here. And so, with all due respect, Chair, when I talk about these threats emanating, it's not as though my client had, by the time his statement fallen due, not only launched an application where formal relief was sought in respect of the delivery of that statement, correspondence was repeatedly sent to the commission staff and the attorneys asking that this matter be dealt with extremely urgently and in an expedited fashion. And my client also waived with respect the very right to a hearing that we are having here because he wanted to know what his position was by the 25th so as to what to do on the 27th. And where I say that those threats from the commission are unconscionable, and with all due respect I speak subject to the chair putting me back in order if I'm out of order, is that the commission in its subsequent letters after the 27th don't even engage with the fact that it's due to them that the entire matter hasn't been disposed of on the timetable that might have been extremely urgent for understandable reasons, but where we had asked for a ruling. So why I'm saying that those threats are unreasonable in the circumstances is not because it was Mr. Karim acting of his own accord. It was Mr. Karim at every stage saying to the commission, place this in front of the commissioners, get me a determination by the 25th so I know what to do by the 27th. And when the 27th came and went, we hadn't heard anything. We only received the answering affidavit on the 24th. So, Chair, with all due respect, I hear what you say to me, and I hear your admonition regarding what I said about the Commission's threats. But there's a factual context that's important to bear in mind as well, and that is that Mr. Karim sought the assistance of the Commission to let him know what to do by the 27th.
You say you hear what I say about what you referred to as threats, and yet you proceeded to say what the commission did is unconscionable. I take strong exception to
I'll withdraw that statement,
that
Chair.
kind of language.
I'll withdraw that statement.
Thank you, thank you. What you've said raises two issues. What
Yes,
you
Chair,
have
I'm
said,
listening.
what you have submitted raises two issues. The first one is, you asked the commission to keep all documents, affidavits and all relating to this matter confidential. The first issue is, I have no idea why Mr. Karim would not have wanted to file his statement if in the face of his request, and there being no basis for him to believe that the statement would not be kept confidential. That's the first problem I have. And then secondly, my point about there having been no change with regard to the deadline. Yes, I've heard what you say, but the bottom line is the deadline was never changed. The deadline stood. So on those 2 points, I still have difficulties with your submissions.
Chair, I don't know if you want me to respond, or
Yes,
those were
you're
your
free to.
concluding
Yes.
remarks?
No. You're free to respond.
No, thank you, Chair.
Mr.
I
Prime
appreciate
Minister.
that.
Yes.
On the first issue about not be kept confidential, I'm not going to rehearse what I said. All I'm going to point out, Chair, is the first time that that was given unequivocally, that the main statement would not be disclosed prior to the determination of the in-camera, was only finally clarified on the 3rd when the directive came out. That was on the facts after the statement fell due.
Just on that, why right from the beginning, instead of tying the filing of that statement to the hearing of the interlocutory application, why did the applicant, in the first place, not make the simple request that that statement should be kept confidential?
But with all due respect, we did, and that's addressed, that's in the founding affidavit and the notice of motion, and it's in the covering letter. And that's part of the difficulty we have here, is that we place all of this in front of the Commission, we ask for an expedited decision and an outcome, and instead of being told, or being told by the Commission, yes, your concern about the main statement is taken care of, it will be held in confidentiality until such time that the in-camera is determined, we don't hear anything. The first time that the Commission puts up an answer is on the 24th, and incidentally, it doesn't deal with the request regarding the in-camera. If the Commission was able to give that undertaking by the 24th when it filed the answering affidavit, then we wouldn't be having this debate, because by the 27th, my client would have filed the statement.
All 15 pages of it, yes.
Yes, absolutely. Whether it's 15 pages, 3 pages,
I know,
100 pages.
I'm just, yeah.
Whatever the case might be, he would have been able to file because the undertaking would have been given. The only time that my client then was given the assurance is when the 3rd comes down, the 3rd directive comes down. And look at what happens. When the directive comes on the 3rd, and the directive says, you must file your statement by the 4th, and you must file it by 9 o'clock, and it will be kept confidential, the statement is filed, no difficulty. So with all due respect, it's a bit unfortunate that my client finds himself in this position in circumstances where he's not in control of these things, and a concern is raised for determination that affects the filing of the statement but is being dealt with in the way that I've just explained. So that's on the first issue regarding the main statement. The second issue, Chair, which I've now forgotten because I've written a note here that says deadline, but I have no idea what that means.
I think I've forgotten also, but probably...
As long as you forgot, Chair, that's fine. That's
probably,
okay for me.
Probably it was that. But the bottom line is that the deadline was never changed.
Yes.
Whatever may have been going on in Mr. Karim's mind, the bottom line is that the deadline was never changed.
But that's it. But you see, that's, with all due respect, it's that catch-22 dilemma that my client is caught in.
Do you know what judges usually say? They say that when counsel says, with all due respect, deep down inside they're saying, what the hell?
Chair, I've never been accused of using such soft language in my entire life, so I'll take that. I'll take that.
Mr. Karim, you wanted me to reformulate my question, to re-put it to you. I thought you had answered my question, but then you went on to muddy it with the threats and the filing of the statement, and all of that was said about it. But I had, the first part of your response was, you are not saying that there's been a disclosure of information submitted to the Commission by Mr. Karim, which he had marked to be confidential. You are not saying the Commission has landed that kind of material in the public domain.
Yes, we're not saying that.
Yeah, that's what I wanted to clarify with you. And then my next question, which I may well now ask, it's now out through you, right, in the engagement with the chair, why you want this application to be in camera. We've had many slip-ups like that from legal representatives, where they do seek something and then they are the ones that actually disclose that which they're asking for.
Yep.
Or that they're arguing. So it's now in the public domain, the reason that you want this application to be in camera.